Hey everybody, welcome. We are back with another business education huddle, is what we like to call them. These are our business empowerment workshops for small businesses, and we are excited to bring to you all today this very informative um, a workshop on estate planning, wills, living trust, all of the above. Although we are here for the small business community, all small business owners are individuals as well. We have families, we have different responsibilities, and we have a guest today that is going to share some information with us that we can then take and share with our family members, our friends. So please, everybody, let's welcome now Miss Theresa, Carter Geoffrey. She will be presenting today. She is the owner of a law office here in the city of Sacramento, really Elk Grove, California. And so we are just so excited to have Miss Theresa today. And I am excited. I'm going to turn it over because I'm ready to just get the information and learn about this life planning things for myself as well. So, Miss Theresa, we are in your hands.
Wonderful. Well, thank you so much for coming, everyone. Let me see. Start. Okay, there we go. First of all, my name is Theresa Carter Geoffrey. I am the principal attorney at the law office of Theresa Carter Geoffrey. I've been practicing law for almost 24 years now, and I exclusively practice estate planning. I've been practicing estate planning for exclusively for the last 9 years. Before going to law school, I was employed at SBC Communications. Now, SBC, they had a program where they would let you go back to school. So I took them up on that, and I ended up going to Stanford University getting my bachelor's degree. After going to Stanford, I decided to quit Pacific Bell and to go to law school to pursue my passion. I passed the bar in 1998, like I said, almost 24 years ago. And I am currently married to Garnett. We've been married for, it'll be 24 years or 25 years, 24 years next month. We have two sons that we are adopting, Jaden and Adam. We've had them in our home for 4 years now. We live in Sacramento County. We've been up here for 20 years. We moved up here so I could be closer to my mom. I practiced when we first moved up here, when I first got out of law school, workers' compensation. That was not my passion. And to tell you the truth, I would still be practicing workers' compensation if it wasn't for the events that followed my mom. She got sick with colon cancer, stage 4. And just like everything else, I approached her situation. I rolled up my sleeves. I got a game plan going. And one of the first things that I did was I got one of my colleagues to come over to do her estate plan. Now, my mom didn't want to do her estate plan. Who wants to think about that when they're fighting for their lives? But I told her what would happen to her children if she had not done her estate plan. So reluctantly, she allowed me to have my colleague come over and do her estate plan. And I can tell you from her subsequent disability, incapacitation, her death, to the distribution of her assets was a seamless transition for my brothers and sisters and I. You know, after we had made the distribution of her assets and I started looking around at other people and seeing what they were going through with their loved ones, either having to go to probate or fighting each other, I thought, well, why is my situation so different? My brothers and sisters, we're still so very close and we're acting like one unit, and other people are bickering and having to spend countless dollars and time in probate court. And the only thing was that my mother planned. And the only reason why she planned was because I educated her. I told her what would happen to her 9 children, excuse me, if she did not do an estate plan. So a light bulb went off and the law office of Theresa Carter Geoffrey was born. My mission is to provide my clients with legal solutions for preserving independence over their long-term healthcare and financial decisions, so that in the event of their disability or death, their businesses and families can proceed in a reasonable and rational way. My goal for tonight or this evening is to inform you about the different tools that are out there that you can use in order to effectively plan for your businesses and your family. So first of all, I want to say thank you for coming and congratulations. And you may say, congratulations for what? Well, congratulations for taking the first step in planning for your family and your legacy. So the ground rules are pretty simple. We're here in this virtual environment, and I can't see you, and so I can't even feed off your energy. So I'm going to try and feed off my own energy tonight. But the simple thing is that we'll hold all the questions till the end, because usually my seminars will answer all of your questions. Not saying that it's going to be 100%, but it's going to be close to the questions that you presently have. So we're going to hold off the questions till the end. I do recommend that as you have the questions, to go ahead and send them in, and Danae will have them for the question and answer period. I hope you all were able to get the slides. If you weren't, I'm sorry, but I recommend to take notes, because when we take notes, it kind of sticks up in here, right? And then we can refer to those notes later and hopefully apply them to our lives. So let's get started. Estate Planning 101. What is it and what do I need to do? By the time we end this virtual session, you will be able to answer these two questions. You will understand what estate planning is and how it is definitely beneficial to every person, since planning is so much more than just a will or a trust. So what is estate planning? It's a process that allows you to control and protect your property while you are alive and well, enable someone else to take care of you and your loved ones when and if you can't, give what you want to whom you want, how you want, and when you want. It should avoid delays, maintain your privacy, all at the lowest possible overall cost to you and those you love. Can we agree that this is a good definition of what estate planning should accomplish? And we can see that estate planning is not the same as financial planning. So what's usually in an estate? Your cash, savings, CDs, stocks, bonds, mutual funds, life insurance, retirement plans, homes, vehicles, investment, rental properties, businesses, jewelry, furniture, tools, antiques. Essentially, all of your stuff comprise your estate. So who is in your estate? More important than the assets that you have is who is in your estate. Your family, your friends, your community, your churches, your charities, even your pets. So before we get into the specific estate planning techniques, let's talk about some common mistakes that I've seen in my practice or I've heard about from other colleagues. Doing nothing, no plan in place. Owning property jointly. Designating a beneficiary. Standalone wills, powers of attorney, and advanced healthcare directives. Living trust, the bare bones do-it-yourself type. We are going to look at each of these this evening. Some of them we'll cover real quickly. The first three are really passive techniques, right? You just don't do anything. And then the standalone wills, trust, powers of attorney, these work well when it's combined with a comprehensive trust. We're going to discuss the pros and cons of each of these. Some of these we can't avoid. And in some ways, help us achieve our desired results, but there are ways to ensure that what you want to happen will happen. So doing nothing. When we procrastinate, most likely we end up doing nothing. This is what happens when we do nothing. We have no plan in place. It guarantees probate. And I can tell you there's 4 things that I do not like about probate. It's public, it's costly, it's time consuming, and it's court supervised. Again, it's public, it's costly, it's time consuming, and it's court supervised. It gives all the control to the state via the intestacy laws. And you have no control. Mistake. I'll take care of this tomorrow. We can't predict when disability or death will occur. I can tell you this. Well, I'll tell you this after the slide. This just happened and I'm still trying to process it. Can't predict when disability or death will occur. Health usually gets worse, not better. We're more likely to become disabled than to die early. Your delay only creates someone else's emergency or stress. Do you know that a female that's age 35 has a 135% chance of becoming disabled with a disability lasting over 90 days than she is likely to die before she's age 65? And for the guys with the same age, they have a 32% chance. Now, this just happened. I just received a call from a family last week. The deceased family member called my office. The deceased family member called my office, didn't schedule an appointment, but asked that I send my documents so they can fill it out. And after they fill it out, they were going to call me to schedule an appointment. Well, time elapsed. They never called me back. And then I get a call from the family. And that deceased person, of course, passed away. They passed away 3 days after they called my office. 3 days. Taking care of it tomorrow may not be possible. We always think we have enough time, but we don't know. And so taking care of it tomorrow may be never taking care of it at all. It's procrastination. Mistake. I'm leaving everything to my spouse. So who needs a fancy estate plan? It guarantees probate. Probate is costly to administer. Like I told you earlier, it's costly. It's public. There's a possibility of multiple probates. You own property in different states. Well, you'll have to open probate in each state where you own property. And probate does not control most property. And we'll get to that a little bit later. Intestacy in California. This is if you die with no estate plan in place. If you die with no estate plan in place in California, and you leave a spouse but no children, parents, or siblings, you do not have any children, parents, or siblings, then your entire probate estate goes to your spouse, including separate property. If you leave a spouse and a child, regardless of the age of that child child gets 50% of your separate property. If you leave a spouse, and several children, then your spouse gets only 33% of the separate property, and then the rest of your separate property is divided equally among your children. Now, I have a case that's been going on for years because people keep passing away, where my client owned a house with her brother. Now, her brother didn't have an estate plan in place. And all along, she thought she owned the property in joint tenancy with her brother. But when she came to my office and I was putting her assets into her trust, lo and behold, her house was owned with her brother in tenants in common. That means they each own it and they each can say where they want their portion to go to. Well, again, the brother didn't have a plan in place, so we had to go probate his share of the house, just his share. And so he was married when he died, but he was separated from his wife for over 8 years. And he had another daughter with his previous spouse that he was estranged from. So now my client has to share this property with people that she's not close to. Well, lo and behold, the spouse that he had separated from 7 years before he died she was deceased herself. So I had to find out that she was deceased. Then I had to find her children. Now her children won't answer any of my letters because their mom, they don't realize their mom owns 25% of this house. And, we can't do anything until we get her heirs to be involved in the case. So without a plan in place, the laws take over. The probate code takes over and says who gets your property, even if those people are no longer in your life. If you have no spouse, I'm sorry, going the wrong way. If you have no spouse but a child or children, then the entire estate goes to your children. If you have no spouse, no children but parents, then your parents get your estate. If you leave no spouse, no children but have parents or siblings, you have a spouse and parents or siblings, then 100% of the community property goes to the spouse, but 50% of the separate property goes to either your parents or your siblings, regardless of whether or not you have even a relationship with them, or even if you would want that to happen. I'm going to do a little case study on Steve McNair. We all know him, right? He died without a will in place. He was killed by his 20-year-old girlfriend in a murder-suicide at age 36. He died without any estate plan in place. His estate was valued at approximately $20 million. Under Tennessee law, his wife, Michelle, will receive 40% of his estate, and his 4 sons, 2 by previous relationship, will receive the remaining 60%. The sons will receive their inheritance when they're either at the ripe old age of 18 or 21. That's instant millionaire at age 18. The IRS froze his estate because he owed $4 million in back taxes. So Michelle had to petition the court to release a family allowance. When he hit it big in the NFL, he purchased a 45-acre ranch for his mom. Even though he considered that ranch to be his mother's, he kept it in his name. So that ranch was included in his probate estate. After he died, his wife, Michelle, demanded that his mom pay rent of $3,000 a month. Well, his mom, Lucille, could not afford that $3,000 a month, so she moved out on the 3rd anniversary of Steve's death. She took what she thought was what belonged to her, the appliances, etc. Well, she received a demand letter from Steve's wife for $53,000 to repay for all those appliances that she took. The probate of Steve's estate provided great stories for tabloids. For instance, an artist who painted a portrait of the McNairs wasn't paid the $5,000 commission. And the reason why she wasn't paid because Michelle didn't think that Steve's other 2 sons by a previous relationship should have been included. Can you imagine how the sons felt hearing that story in the court? McNair's prized restaurant in Nashville, the Gridiron 9, was closed shortly after his death. Michelle tried to sell it, but she was blocked by his cousin who co-owned it. So a few facts. 92% of adults under the age 35, prime parenting age, do not have an estate plan. They need one, especially if they have minor children. Parents who plan use a will to name their choice of guardians for their children. But if both parents die intestate, the guardian will be determined by the court. 68% of African American adults and 90% of Hispanic adults do not have an estate plan. Is it because we do not love our families as much? No, it is because we are not taught. Because when we know better, we do better. This means that people of color are the ones who are in the probate court, wasting valuable resources which could be used to help their heirs create lives that we desire for them. Another thing is that we can be a penny wise and a pound foolish. We don't want to give our hard-earned money to an estate planning attorney, so we say we just won't do an estate plan. Let me tell you, can be more costly than dollars and cents if you do not properly plan. Owning property jointly. I have my finger on the right button now. I'm sorry, everybody. It's very common. People put their kids' names on their property all the time, and I can tell you some horror stories. It's very common. Married couples do it. Anyone can be joint owners of property. Jointly held property has its own rules regarding ownership and transfer on death. It is important to understand the rules in order to determine whether joint property is the appropriate estate planning tool for you and your family. It's really important to understand the drawbacks. So, problems with joint tenancy. Some of the problems with joint tenancy, it creates unattended heirs. You remember the story I told you about my client that we're in probate now, where she thought she owned the property, and now it's going to be with people she doesn't even know once we locate them. So let's have another little example. You have a will, and your will says that you leave everything to your spouse, right? But the largest asset that you own jointly with a brother or business partner. And even though your will says everything goes to my spouse, because you own that property jointly, it goes to the surviving joint tenant. It's the game of survivorship. The last joint tenant owns everything. And it does not totally avoid probate. What happens when that second joint tenant passes away and they didn't do an estate plan? Or what happens if you become incapacitated? And you become incapacitated, who's going to be able to speak for you at that point? It is not controlled by wills or trust. Joint tenancy is not controlled by wills or trust. Designating beneficiaries. These types of accounts that I'm going to list here on the screen, they all have one common denominator. You do your estate planning when you open the account. We all do this. It's pretty simple. It feels good. Feels like we're doing the right thing, right? With our 401ks, life insurance, paid on death accounts, transfer on death accounts, IRAs, naming the person who you want to receive the money in a particular account on your death, transfer on death deeds. All these properties listed here are not subject to probate, but they could be put into your estate plan if necessary, if that's what you want or how your plan is designed. And then that way we can ensure not only it goes to the right person, but the distribution occurs the way you want. So the problems with beneficiary designations, subsequent marriage issues, influence of spendthrift children, creditors, predators. Now, problems with beneficiary designations, it does not protect your spouse. Now, we had a man who, he had a life insurance policy, right? And he bought it when he was married to his first wife. He divorced his first wife, he married his second wife. He never changed the beneficiary designation form. And when he died, who got his life insurance policy? His first wife. She received it. Another case where a man bought a life insurance policy when he was really young, right out of college. And so it was real cheap, and he got a large whole life policy. He named his best friend, who was his college roommate, and his brother as beneficiaries. And the money was being taken out of his checking account, so he just forgot all about that life insurance policy. Well, he goes and he marries the love of his life. He has children, and then finally he passes away without changing his beneficiary designation form. Who gets the life insurance policy? His brother and his former best friend, who he didn't even speak to anymore. And so those are the problems of beneficiary designation form. It does not necessarily protect your spouse. It does not protect or care for minor or adult children. There was this guy who had $300,000 and 6 kids. And so he wanted each one of his children to receive $50,000 upon his death, right? So he got the bright idea that he would open 3 certificates of deposits and put 2 kids on each account as the paid on death beneficiary. Well, one of his children, they predeceased him. And so when he died, 4 children received $50,000 each, and 1 child received $100,000. Nothing went to his deceased child's children. So what he did was he effectively disinherited his own grandchildren. It can cause unfortunate results. And it does not prepare for incapacitation. The beneficiary designation form can't speak for you if you became incapacitated. What if you needed to downsize your household if you became incapacitated and move into an assisted living facility, or to protect your assets from creditors, even Medi-Cal? If you are incapacitated, the designated beneficiary form cannot help you out. There's no protection for what I call creditors or predators. You have no control. Mistake. I have a will, so my estate plan is in order. It may be too simple, not accounting for changes in perspectives, your perspectives, your circumstances, the people in your life, or the law. Solution. Update your estate plan often. You may need to add, delete, or change certain provisions. You may prefer or need a trust-based plan instead of a will-based plan. Wills. It contains sterile legalese. It may not effectively cross state lines. So what happens is, if let's say that you created your will here in California, and then you move to Arizona to retire, and then you pass away in Arizona. Well, Arizona is going to look to California's law just to see if it complied with the legal requirements to sign a will, that it was signed in front of 2 people who knew that it was a will, right? After that, they will use Arizona's laws to interpret your will. And I can tell you, in Louisiana has a really crazy way of giving property, even if you have a will. If you have a spouse, your spouse is going to get percentage of it, regardless of what your will says. And so Louisiana would look to California, make sure that it was signed properly, and then they will use Louisiana's laws to interpret your will. It does not become effective until you pass away. That's the biggest problem with wills. They can't speak for you if you became incapacitated. Who's going to take care of you? We can't use your will because, again, it doesn't become effective until you pass away. And it does not protect against living probate. And we will talk about this later, but living probate is conservatorship. It cannot speak for you in conservatorship proceedings. And so a will is just something that we stick in the drawer and we don't have to look at it again until you pass away. And it may not protect your children against those creditors or predators, like I said before, when the heirs receive their money outright. Unintended heirs. So Marilyn Monroe, she died at age 36. Her will left 75% to her acting coach, Lee Strasberg, with wishes to donate to charity. Strasberg later married, and at death in 1982, his estate, plus all of Marilyn's licensing and royalty fees, went to his widow, a complete stranger to Marilyn, and not a dime to charity. Marilyn Monroe's licensing fees generate over $1 million annually, and someone she never met is receiving her royalties, and that's a shame, right? So there's types of probates. There's two types of probate. There's the living probate, the conservatorship, and then there's the death probate. Many people are not aware that about the conservatorship. This happens while you are living. If you are too ill or disabled, you and your assets can wind up falling into court conservatorship, where the court takes over. Most people fail to address what will happen to them if they became incapacitated. Why? Because illness and injury are not things that we expect to happen. You're not thinking of terms of when you're going to become disabled. But here's the thing. Although a lot of people don't think about it, they probably never heard the statistics. I gave you some earlier, but think about this statistic. If you are under age 65, there is a 4 to 5 times greater chance that you will become disabled than you will die before you turn age 65. And if you are over 65, there is a better than 50% chance you will be ill or disabled for a minimum of 1 year, during which time you will not be able to handle your affairs. So taking care of you during any period of disability is maybe even more important than what happens after you're gone, right? So if you're not properly prepared, you and your affairs may end up in probate court. And with death probate, both of these are judicially overseen. Death probate here in Sacramento County takes between 18 months and 2 years. And with COVID, it's even taking longer. So living probate, it's judicially overseen. A conservator is appointed to administer your assets. The conservatorship is either if you're mentally incapacitated or you're minor, you're under age 18. It's expensive, petitions filed, annual accountings are required, court investigator has to investigate, counsel for the conservatee is appointed, and who's paying for all of this? It's coming out of your estate. And it does not end until death or reaching the age of 18. Probate at death. Probate at death is the legal process of paying a decedent's debts and retitling all of that person's individually owned assets into the names of the beneficiaries listed in their will or heirs determined by law. During death probate, a personal representative is appointed. They have to notify any potential creditor of the right to file a claim for payment. They have to publish notice in the newspaper to any unknown creditors. You know, like if you're looking at the Sacramento Bee and behind the one ad section, there's all these notices. Those are required legal notices that have to be published when you pass away. The personal representative has to inventory and have all the assets appraised. They have to report everything to court. They have to seek the court's permission for everything. It's lengthy. It's between 18 months to 2 years. And the proceedings are public. So when you pass away, the court opens a file, right? The file lists all of your name, your information. It lists all of your beneficiaries, their names, their addresses, their ages. It lists all of your assets. What's the value of all these assets? Who's going to get these assets and when they're going to get these assets. I can go down there and look at your probate file. Your next door neighbor can go down there and look at your probate file. But more important than that, a con person can go down there and look at your probate file. Now, do you think this information is important to a con person? Absolutely. I say that if you allow your family members to go through the probate process, it's like putting a red bullseye on their back. And probate is costly. So what's the cost of probate? Well, in California, the fees are set by statute. The personal representative and the attorney are entitled to the same amount. And I have those asterisks right by the personal representative because used to, it doesn't happen anymore, but used to, when a family member was a personal representative, they wouldn't take a salary. Each one are entitled to the same amount. The fees that they're entitled to are 4% for the first 100,000, 3% for the next 100,000, 2% for the next 800,000, 1% for amounts up to 9 million, and cost doesn't start there. Cost also includes the filing fees, the publication fees, and miscellaneous expenses that we estimate is about 1% of an estate. So the average cost of an administration is between 2 and 8% of the gross value. And I'm yelling at you, gross value, right? Not the net, the gross. So what does this really mean? Let me give you an example of probating one simple asset. Let's say that the family had a home and the home was worth $550,000. So the gross estate is $550,000. The estimate cost of probating that one asset is $33,000. That's pretty expensive, right? Now, the effective rate is 6%. And that was that 4%, the 3%, 2% that all equaled out to $33,000. Now, let's say that same family had debt. They had that house, but it had a mortgage, $250,000 mortgage. So the net estate is $300,000. Well, the estimate is the cost of probate is still $33,000. The effective rate is 11%. So we start adding debt, and the effective rate, as the effective rate grows, that means less that's going to your heirs, right? It's taking money from your heirs. So probate is not just for wealthy people. It's for anyone that has assets in their individual name when they die. And those assets total over $166,250. So how do we avoid living and death probate? We use a revocable living trust. We use a power of attorney that's effective when incapacity is determined. We provide personal care guidelines, have and register healthcare documents. Whenever I have my clients, when they sign their healthcare documents, I tell them to take them down to their doctors and have them put into their medical files. Use standby guardianships and medical consents for minor children. So what is a living trust? Some people call and say, I want a living will. No. You're talking about a trust. So let's talk about what a trust is. It's a legal document similar to a will. A will says, this is what I have, this is who I want it to go to, and this is who's in charge, right? Well, trust says the same thing. It's just a will substitute. So how a trust works? Well, a second step occurs in a trust that doesn't occur with the will. See, after you design your will, you then put your assets into your trust, either by retitling those assets into your trust name or naming your trust as a beneficiary to receive those assets upon your death. And then you are the original trustee. And then you name successor trustees who will step into your shoes in the case of incapacity or death. And those trustees follow the specific instructions and manages their property. And then when you pass away, the trustee will then distribute the assets to your beneficiaries according to your specific instructions. During your lifetime, it's business as usual. You are in control. You can still open and close accounts. You can still make investments, buy, sell, refinance your real estate. Your property taxes will not change. Your income taxes filed the same way. It's the same. And it's amendable or changeable throughout your lifetime. So really, what is a trust? It's merely a standby device. It's standing there quietly holding all of your assets so that in the event of your incapacity or your death, it springs into action without going into a court of law. That's the important part. It springs into action without going to court. So let's see what else we could talk about with living trust. Well, living trust, there are various types that are commonly promoted. There's the bare bones trust, the do-it-yourself, or there's the fully funded trust with powers of attorney and healthcare directives and other important documents. And I can tell you what funding means. Funding is a term of art, and it means just the process of transferring your assets out of your name and putting it into the name of the trust. So if you own a house, the John and Mary joint property house will then now be changed to the John and Mary living trust house, right? And so that's funding. It's the transfer of the assets out of your name into the name of your trust. Now, a lot of people, a lot of companies, what I call the warehouse kind of type of companies, they only will create your trust. They won't put the assets in it. And without the assets in it, your loved ones still have to go to court. So the bare bones living trust type. These are the out-of-the-box software you can buy. One size fits all. Someone else decides important matters for you. Cookie cutter design. No personalized planning at all. Assembly line process. If all you care about is avoiding probate, and if these types of trusts are created and funded properly, then this type of trust may achieve your goals. But if you want a plan that is customized to fit your needs, goals, and plans, then this is not the best option for you. Because it's often not funded or improperly funded. Non-trust assets will still have to go to probate. Its improper property ownership may prevent implementation of the trust plan, may cause more harm than good. Aldridge from the LegalZoom. Aldridge, Mary Aldridge, she used LegalZoom to create her estate plan. She lived in Florida, and she had a brother who was very wealthy, a sister who was wealthy, and a brother who was not so wealthy. And so she really wanted to take care of her brother who was not so wealthy. She wanted to take care of him and his children. Well, the wealthy sister died and left Mary a lot of wealth, right? And then when Mary died, her wealthy brother's two daughters took the poor uncle to court because Mary left one simple clause out of her estate plan. And because she left that one simple clause out of her estate plan, all of the sisters, that wealthy sisters' assets that she had inherited went to the wealthy brother's daughters. And so it may do more harm than good. LegalZoom, and I visited their website a number of years ago, and I saw this, and I thought, oh my gosh, if I read this and I was using their product, I would be kind of scared. So I thought, well, maybe I'll share it with you. LegalZoom's website disclaimer: communications between you and LegalZoom are protected by our privacy policy, but it does not provide attorney-client privilege or work product. LegalZoom provides access to independent attorneys and self-help services at your specific direction. We are not a law firm or a substitute for an attorney or law firm. We cannot provide any kind of advice, explanation, opinion, or recommendation about possible legal rights, remedies, defenses, options, selection of forms, or strategy. So unless you are an attorney yourself, how do you know what's available for you and your loved ones? What's available for your specific situation? That's why you use attorneys, right? Because we can make the recommendations, we can provide the legal advice, and provide remedies and defenses. LegalZoom can't do that. And so what they say, they are a bonded legal document assistant. What a bonded legal document assistant is this: what you put in is what we're going to spit out. Just like if you put in mail merge, if I'm aging myself, but we used to use a program called mail merge back in the day. And whatever you put in, if you put the city in wrong, then it would go to the wrong city. It was nothing in there that said, oh no, that would flag and tell you that something was wrong. And so that's what LegalZoom is. It is just a bonded legal document service. Attorneys are so much more than that. So, what is a fully funded living trust? It's like a packed suitcase. It's, women can probably understand what I am talking about. No matter how hot it is here in Sacramento, whenever we go away on a little trip, we always pack a sweater for just in case. Well, the living trust that I design have what I call little sweater provisions. There are provisions that we may or may not use it. It's just in case, because we don't have a crystal ball. We don't know what is going to be, what your life is going to be like, who's going to be in your life, what your asset makeup is going to be when you pass away. So it's filled with items that you may or may not use. It holds property for ease of transfer to heirs. You have the ability to put in and take out property as needed. It's managed by a trustee. Now, like I said before, you're the original trustee, right? But then you'll name successor trustees, which could be an individual, a set of individuals, a bank, or corporate trustee of your choosing. I am seeing more and more people use corporate trustees nowadays than ever before. In fact, I'm on my, I'm 50% completed with taking my fiduciary practice licensing, where I can be a trustee, not of any trust that I create, but of other folks that may need a trustee because they don't have anyone that they know in their circle to be a trustee. So it could be anyone of your choosing. The trustees can be replaced as necessary due to death, change in circumstances, etc. A fully funded living trust ensures long-term control over the assets. You set the rules of inheritance. You set the rules successor trustees must follow. You set the guidelines for care on disability. You can plan for many different situations: children with different needs, pets, remarriage of a spouse, charitable contributions, special religious desires. And it's easily amendable. As long as you have the mental faculties to amend your trust, you can amend it. So why a living trust is better than joint tenancy or a will? Now I'm going to go into a little bit more detail to compare why a living trust is different and better than the two most common forms of estate planning: joint tenancy and wills. Those are the two most common forms of estate planning: joint tenancy and a will. Borrate sale caro. Does anybody know what that means? Does anybody watch the People's Court? She always says, Borrate sale caro. Okay, and you'll learn what that means in a minute. So why do people favor joint tenancy more than, or wills more than they do a living trust? First of all, they're cheaper to set up. Joint tenancy, when you add those two magic words to an account, it costs, well, nothing, right? Or you can add someone to a will, a grant deed. You just have to pay whatever the county recorder pays or charges, right? So, you know, in Sacramento County, that could be 26 to $100. That's pretty easy. That's definitely cheap, right? There's not a whole lot of paperwork that you need to do after that. And if one joint tenant dies, typically the property goes to the other without a lot of additional paperwork. A will may cost $1,000. Not only are they cheap, but they're pretty simple and easy. Well, a will, you just, after you complete it, or you draft it, you put it in your drawer and you forget about it until the person passes away, right? That's pretty simple and that's pretty easy. So cheap, simple, and easy are very attractive words. As with many things in life, we have a lot going on. So when we see cheap, simple, and easy, we're thinking, hey, that's the route I want to go. But we should never use cheap, simple, and easy for important things in life. And estate planning is probably one of the most important things you can do in life. So cheap and easy can be a big mistake. And I'll tell you why. Barate sale caro. The cheap comes out expensive. Let me show you why. Distribution to the right people. This is important whether you're married or not. The very first reason we have, regardless of circumstance, the very first reason or objective for doing an estate plan is to make sure that what we worked on or worked for our entire lives can go to the right person, right? When we pass away. We don't want to leave it up to the court. We don't want to appoint perfect strangers or distant relatives or whoever that may not be who we intend to have it or to be our heirs, right? Well, you may be surprised that with joint tenancy, it doesn't guarantee that it will go to the right person. Let me give you a few examples. Mom over here, mom has a will, and her will says, I want everything to go to my 3 children equally, right? And her will says, if one of my children pass away before I do, I want my deceased child's share to go to my grandchildren to receive their deceased parents' share. And that's the way most estate plans work, right? Because these grandchildren probably have more financial need because they've lost a parent, right? Well, that's what mom's will says. Now, over here, mom, she puts her 3 kids on her house. She says, you know what? I know that my house will make my will go through probates, and I want to avoid probate. So I'm going to put my 3 kids on the house. So when I die, they'll get it. They'll own it equally, right? But one of her kids passes away before she does. What happens? Even though her will says everything equally to my children, my 3 children, when she passes away, her 2 living children own 50-50 of the house, and her grandchildren don't own anything because joint tenancy overrides everything else. Only the 2 surviving joint tenants will receive the entire estate. Let me give you another example where joint tenancy can go very wrong. A common situation: dad passes away. Sister, she moves into the house with mom, right? And so daughter, I'll call her daughter, she moves in the house with mom. And she tells mom, Mom, I'm doing your banking. You might as well just put my name on the checking account. And mom says, okay, I will, but as long as you share with your 2 brothers. Sister says, okay, I'll share with them. And then she convinces mom, you should put my name on the house too. So mom puts her name on the house with sister promising that she will share with her brothers. And so mom passes away. Is daughter legally required to share with her 2 brothers? No, she is not legally required to share with her 2 brothers. She may be morally required, but she's not legally required. And I can tell you, if those 2 brothers weren't helping, I doubt if she will share with her brothers, right? Now, you probably say, with a will, a will, I can make sure that it is divided equally the way I want it to go to. And if a person predeceased me, I can make sure it goes down to whoever else I want to, like to their kids, right? And you're right. But where there's a will, there's a probate, right? There's a probate. Now, a living trust can avoid both probate and make sure that the distribution goes to the right person. May defer distribution until you think it's appropriate. The second item is very important. The cash people will receive from you is much more cash than you have right now. The cash people will receive from me is much more cash than I have right now. How is that possible, Theresa? Well, it's found that in 95% of the cases, the family will sell the home after you pass away. And if you think about that one asset, that's probably a few $100,000, right? And then your life insurance, well, it matures upon your death. And that retirement account that you've been rolling over and over and over. And then, of course, you got cash accounts, stocks, your cars. And what about all of those antiques, those family heirlooms? Well, they're going to have an estate sale, right? The cash people will receive from you is much more cash than you have right now. And it's probably much more cash than they'll receive all at once ever in their whole life. So think about it. Are they capable of receiving all that cash all at once? Let me ask you a question. How long does it take for a person to go to a luxury car dealership after receipt of his or her inheritance? 72 hours. So you may want to defer the distribution over time, or when they reach certain ages, or as they need it. You may not want them to have it all at once. Unfortunately, in joint tenancy, that's exactly what happens. They get it all at once. And when I say all at once, here in California, all at once means at the bright age of 18. I'm sure they're going to go to college, right? Now, with the will, you're probably saying, with the will, Theresa, I know I can defer distribution until it's right. I know I can defer it over time. And you're right, but there's one problem with the will, right? Where there's a will, there's a probate, right? With a living trust, we can avoid the probate and we can defer the distribution until it's appropriate. may avoid court interference, delays, expenses, and publicity. Now, some people think that joint tenancy avoids the problems of probate. Well, first of all, except on certain accounts where either one person can sign or the other can sign, joint tenancy doesn't help at all if you become incapacitated. Someone can't sign your name to your deed or handle your other business affairs. So you'll probably wind up in what we call conservatorship. With joint tenancy, when you pass away, well, maybe after the first joint tenant passes away, the second one can receive the assets without going to court. But what happens when the second one passes away? Now we're in court. Well, what about a will? Well, a will, like I said, we put it in a drawer until we need to use it. So a will can't speak for you if you became incapacitated. And watch this. A will is just a ticket to probate court, right? It just gives a judge instructions on what to do when you pass away, who to give my assets to. So with wills and joint tenancy, it does not avoid both the living and the death probate, but a living trust can. A living trust can also help reduce or eliminate estate taxes if you're married. Now, right now, estate taxes are they're off the chart because of Donald Trump. They're like 22 million. So only 1% of the population is affected by estate taxes at this point. And that law is due to sunset in 2027. So it may go back down, but we'll see. But right now, unless you have over $22 million, you don't have to worry about estate taxes at this point. So why do trusts work? They work because you've created a plan that will take care of you during your lifetime. They work because you have total control over the plan during your lifetime. They work because you have outlined what you want to happen in the event of your disability, how you want to be taken care of, who will make the decisions on your behalf. They work because you make your loved ones aware of your long-term goals, personal values, and desires, your charitable giving, your pets, your religious beliefs. It saves money in the long term. Minimize or avoid probate and the accompanying cost. It saves estate and income taxes by maximizing use of available deductions and exemptions. And it establishes a plan that allows you to maintain control over the assets you worked hard to accumulate over your lifetime, not just during your life, over the long term. Do no harm. I'm talking fast because I'm over my hour limit. So anyway, I do no harm. I not only ask, will my fortune be safe with my children? I also ask, will my children be safe with my fortune? Andrew Carnegie. Wealth is like a blazing fire. It can warm and cook, or it can burn and destroy. The imminent dangers of excess access to unearned wealth are very real and very serious. Consider Jack Whitaker. He was the 2002 Powerball winner. Just Google him and you'll see what happens when you receive a lot of unearned wealth. So outright distributions may be wrong if your beneficiaries are currently too young. So if any of your beneficiaries are listed on this screen, then outright distributions are wrong. You should not allow them to happen if they're too young. Now you're probably saying, wait a minute, Theresa, my beneficiaries aren't too young. My kids are old or older. But what does your trust say, or what does your will say, or what does the law say? If one of your children predeceased you, it goes to their children. Now, are they too young? And sometimes too young may not just be the age, right? Can you imagine if you were 18 or 21 and you got a few $100,000? Probably a disaster. I know it would have been a disaster for me. So what you do with a beneficiary that's too young, you do what's called a stage distribution. And what I mean here is that they get it over a certain number of years, or they get it at certain ages, or they get it at certain periods of their lives, but they just don't get it all at once. You could even tie it to incentives, like building your legacy. I bet if I ask anyone that's listening to me, what's the best thing you can give to a young person? I bet you would say education, right? Well, you can tie it to education incentives, such as, you'll pay for the education, or pay for them to graduate from college, or if they graduate from college within 4 years, they get a bonus. Or you could just tie it to anything that you want. You just dangle it in their face, the carrot in their face, to make sure they achieve the goals that you want for them, even if you're not here to see it yourself. Or you can tie it to age, maybe 25% when they turn 25 or graduate from college, another 25% when they turn 30, or 25% when they turn 50, or all at 60, whatever you want, whatever legal distribution process that you have or that you want for your loved ones, you can make that happen. Now, elderly, ill, or disabled. Now, I'm not talking about people that are receiving Medicare or Social Security. I'm talking about the people who are receiving Medi-Cal or Medicaid or SSI. What happens if they receive an inheritance? The government is going to say, pay it back, we're going to cut you off, or spend it down, right? So what you can do in this case is you can do what's called a supplemental needs-based trust. This is a special trust that under the law permits the trustee to supplement their government benefits, but doesn't disqualify them and doesn't let the government get reimbursed for the benefits that they've already given. Have a drug or alcohol problem. Clearly, these people should never get anything outright, right? So what do you do for these people? Well, you do what's called a lifetime trust. Here, a trustee is going to, that you appoint, will manage things for them. They could even be co-trustee with the trustee, but they just don't have access to the money. And you give the trustee a broad standard on how you want the assets distributed. You can say, I'll pay for rehab, or I'll pay for their I'll pay for rehab or any of the fines that they have, so they can get their tickets paid for, so they can get their license, etc. But they just don't get to handle the money themselves. Not good at handling money. Well, we know someone like that. We give them $1 today and it's gone tomorrow, right? So what do you do with these people? Well, you do what's called a spendthrift trust. And what a spendthrift trust allows, the trustee would pay for things directly, like pay for their mortgage or their car, but they just don't give the money to the beneficiary directly, because what will happen, the beneficiary will spend it on something else, right? And so that way, you could tie it also to different incentives, such as if they're not good at keeping a job, you can tie their distribution to how much money they make at the end of the year, and then every year you match what they make, their W-2. You could tie it to different incentives. They just don't get it all at once. So even if you got these covered, what if their situation changes after you're gone? Will your trust adapt? And you just want to make sure that you give the trustee enough discretion that they can adapt to any change in circumstances. So let's assume that none of these problems exist. You still want to give outright distributions? Probably not. What's the number one way a person loses their inheritance? Through a divorce, right? And you're probably saying, Theresa, this is a community property state. How can they lose their money in divorce when we know inheritance are separate property? Well, what happens is, and you're absolutely right, inheritance is separate property. But as soon as we get that money, we start supplementing our lives. We go buy the new cars, we fix up our house, we start taking these vacations, we start paying for the kids' education. Then suddenly our spouses start relying on that inheritance, right? And so what we've done is slowly transmuted our inheritance from separate property to community property. And then our spouse goes and gets a fancy divorce attorney and says that we want half of the inheritance. Creditors or bankruptcy can grab it. As soon as that inheritance is in the heir's individual name, then it is subject to their creditors or bankruptcy. If they file bankruptcy 2 years before or 2 years after receiving an inheritance, the trustee of the bankruptcy will want that money. A fortune hunter's lawsuit can grab it. Like I said before, subject to con people, they know when you're getting your inheritance if you have to go through probate. And trust me, they are out there figuring out ways to get your money. The government can force it to be spent down or paid over to them. If they're on governmental needs-based assistance and they receive inheritance, the government's gonna, here in California, say you got to repay us, and they're gonna make them spend it down until they don't have enough money, and then they get their benefits again. So this can happen even if none of the previous problems existed. So what I've been saying is that you do not want distributions to come directly out of your trust to your beneficiaries anymore. This is the old way, which exposes them to problems. Case study. So we have Bob Jr. He is the star player in the family. He went to college. He's got a good job. He has a high maintenance wife who is trying to keep up with the Kardashians. He's in a risky business. He's a doctor or a real estate developer, and if he got his money outright, he would be subject to a second estate tax. What happens to his inheritance? It's gone. Then you have your daughter, the only daughter, Jane, dear old Jane. She's married to a terrible husband who we call Dennis the Menace behind his back. What happens when she gets her inheritance? Because she lacks financial experience, it's gone. Then we have your third son. We don't know what Jim's problem is. He either has creditor bankruptcies, government benefits, whatever his problems are, his inheritance is gone. So the better way is to keep it into a living trust for each child. So each child has their separate trust. And that way it's better protected from bankruptcy, from creditors, from divorce, from lawsuits, from the government. And so I'm going really fast because I am terribly over my time. So special issues with married couples with young children. Who will take care of your children? Do you have any special instructions? Who will manage for your children's money? Is it the same person who's raising them? What if they have children? Are they going to spend your child's money on their children? And when do they get their inheritance? For what purpose? Special issues for singles. Who will manage for you if you become disabled? Who will get your assets? When and how long? For what purpose? Mistake. My family will make financial and healthcare decisions for me. Disagreement among family members, even if they're all doctors or lawyers. Solution is to execute ancillary documents, not only the wills and trusts, but some ancillary documents, healthcare powers of attorney, and financial powers of attorney. Name level-headed decision makers. Might not be your spouse or parents or siblings. Should have successors. I always say, give me 3 successors, people, because if something happens, we just want someone else in line just in case. Powers can be limited or pretty broad. Intentions can be stated in detail. So what's the power of attorney and healthcare directives? Powers of attorney give someone else authority to act for you in financial matters, gifting, healthcare decisions, instructions on long-term healthcare. Advanced healthcare directive, instructions on healthcare and when to withhold medical treatment. So a comprehensive plan is a plan that is fully funded with instructions on alive and well, incapacity and death. You should have a pour over will, which has the guardian provisions for your minor children, and it directs anything that's not in the trust upon your death, pours over into your trust. You should absolutely have the healthcare powers of attorney that empower your loved ones. They're not making decisions for you. They're only giving voice to your decisions. Powers of attorney in order to manage the assets and the items that's outside the trust, be able to act on your behalf. The advanced healthcare directive, some people call it the living will, but it's basically when to withhold medical treatment, end of life decisions. memorial instructions so your loved ones will know how you want to be memorialized, general assignment for personal property, make sure all of your tangible assets are into your trust, and personal property memorandum, because people fight over the things more than they fight over the money, because the things have the personal attachments to it and the more emotional ties to it. And so you want to have a personal property memorandum to make sure that you are giving your items away so your loved ones don't have to fight over it. So when should you plan? Today, your planning opportunity is between today and when you have mental incapacity. Since we don't know when mental incapacity could hit, the plan is really, you need to start today. The end result is peace of mind. And now we're going to go into our question period.
I do not see any questions in the chat. Just a lot of really good comments about this being really helpful and great information that was shared today. So I do want to thank you for coming on. And I do want to put your contact information on the screen so that folks can contact you with any questions, or if they need your services to lock you in. You can contact the Law Office of Theresa Carter Geoffrey. I always mess up the last name, but Theresa Carter Geoffrey, I think it is. You can reach her at the website listed above, also at 916-572-1998. She also has an estate planning learning center. So if you want more information and tools and tips, you can contact her directly. You can also check out the link as well. And for anybody who's looking to, receive some of these types of services, we want to encourage you to contact her. She is the guru. So we want to encourage you to contact her. R. Waters Calloway has been just so grateful for this presentation and just says, thank you so much for this thorough presentation and information. Any last words? Anything else you want to share, Ms. Theresa?
No, only that I was looking in the wrong camera the whole time. I'm so sorry, people. I'm sorry. Okay. So here are my last thoughts. The bitterness of cheap quality remains long after the sweetness of the low price is forgotten.
Mm-hmm. That's good. Yes. So remember, folks, don't always go after the low price just because it is the low price. Get with Miss Theresa and she can steer you in the right direction to best benefit your needs, the needs of your family, and what your goals are with your estate planning. So if there's nothing else, Miss Theresa, there's no questions in the chat. We thank you all for joining us. We thank you, Miss Theresa, for partnering with the Black Small Business Association and presenting on today. And we want to give you all back your Tuesday. Have a great evening, everyone.
Thank you. Thank you so much.
Thank you.